All right. Hello, everyone, and welcome. We'll go ahead and get started now. Thank you so much for joining us today. My name is Emily, and I'm the marketing director for Clinkscales Elder Law Practice. And we are very excited to bring you this webinar today, specialized for our incredible first responders and their families. Please feel free to send any questions that you may have to me in the chat box, which is located at the bottom of your screen. And at the very end of this presentation, we will address any of those questions that you might have. In our webinar today, we have attorneys Jenny Walters and Adam Dees from Clinkscales. Adam has been with Clinkscales for around 3 years and has a very strong background and expertise for tax practice. And Jenny has been with Clinkscales for almost 11 years now and loves focusing on Medicaid planning and helping people pay for long-term care. That being said, I am now going to hand it over to Adam and Jenny to get us started.
So I think before we get too much further in, Emily neglected to say that this is a topic that is near and dear to her heart because her fiance is part of the first responder community and is a law enforcement officer here in Hayes. And so she was the one that said, hey, let's do something. And before we get too much further along, I want to specifically thank her, thank all of our first responders for the work that they're doing to keep us safe, to be prepared, and to just give us some peace of mind, knowing that that you are out there working for us. And it's really an honor and a privilege to be sitting down and talking with you about these types of things, because as much time as I know you spend worrying about keeping us safe, we spend the same type of time and thoughtfulness thinking about our own families, but also wanting to think about yours and keeping them safe if something would happen to you on the job or otherwise. So speaking of which, think about how long, you might run into a burning building. You, as a first responder, may enter into a gunfight. I love this cartoon because I think it describes where a lot of our families are at. You know, maybe you would run into an accident in a home, a church, a school, a business, or some other type of crisis, a supermarket or a wreck on the side of the road. And it took a long time for you to get ready for that, for a fire, 6 months, 2 years of training, for a gunfight or a law enforcement situation, 2 years or more, for the accident, 6 months, 2 years, longer than that to respond to someone who's in a health crisis. And so, if we're going to spend that much time preparing to enter into those dangerous situations, maybe we should sit down and take a little bit of time. And that's where, Jenny and I work with folks, because we spend that time to worry about what happens to everybody else in your family if there's an accident or an event. If we do end up with a health crisis with stroke or Alzheimer's or COPD or a heart attack or diabetes, what happens if maybe families don't get along, or you're in a blended family? And then the very scary part is if we have lawsuits or creditors, maybe divorce, maybe remarriage. And some, individuals that help us end up in debt, end up with a disability, end up with substance abuse. And so all those things can just wipe out your savings. They are going to cause turmoil and stress. And so we want to sit down and talk about ways that you can make those situations easier for yourself, but more importantly, easier for your loved ones, so that if you enter a crisis situation to help another family, and because of that, that doesn't lead to a crisis in your family. So if you knew, we plan ahead for life, college, retirement, growing older, for disability, if someone's hurt on the job or otherwise, or for death, and then for your family and what happens to them. So again, we know that we've invested some time for you to protect us. You've invested your years of your life. You continue investing in training. So let's also invest some time and money to protect your loved ones from these moments. So what do we work on? We want to integrate estate planning, asset protection, long-term care strategies, caring for your children, but having a plan for your family so that you and they can weather any storms, can meet goals, meet dreams that you have for you and for your children, like Jenny and I have for our families and for our kids, and then protect that so that you can, do those things that you've chosen to do without losing everything and having worked a lifetime to build, while at the same time we protect those that you love. And so the first kind of step in this is putting together a written legal plan of who's going to care for your children if you have children or your other loved ones. And so, Jenny, what does it look like to start down the path of getting a written legal plan for you and your kids?
So first of all, I just want to say that when I was preparing for this, this gets into some uncomfortable topics because Adam and I, both of us have small kids, and just thinking about these situations can get pretty uncomfortable and scary. And then on the other hand, I was thinking we're going to be presenting this to people who that's what they do, is run into the people that this has happened to, that have been in accidents, that horrible things have happened to. So we're well aware of that this does happen to people. So let's first talk about the little ones. And we've got cute little Rachel up here for Adam. I added mine later, but so let's talk about how we can take care of them, and then we'll get into taking care of the parents and the older folks. First of all, we want to make sure that you have a guardian conservator for your kid, because if your kid's under 18, you need to appoint somebody that's going to be taking care of them. And I want to differentiate. We're going to be talking about a guardian really to take care of the person, to raise and care for them, and then a conservator to manage the inheritance, basically the financial piece of it. In the long term, let's give a situation where, an example where both parents have passed away and the kids are minors, talking about our kids. If there's no plan in place, and I love this judge and he's going to come up a couple times, because what happens in that situation? Well, a judge decides. And so we want to prevent a judge having to decide. So here's a great example of how this could go really badly. You got a family that's in a car accident. The parents die. There's 3 kids. They go into foster care for a short bit. And then you got 2 aunts that want custody. And so they fight over the kids with lawyers and thousands of dollars. This is kind of the extreme, but this is a real life example of what can happen if you don't have documents in place. And so let's talk about, even if you don't pass away, you're incapacitated for the long term. Even if you nominate, which is the right thing to do, have guardians and conservators in your will, that may not be enough. You may also need to sign some authorizations for your kids so that they are taken care of while you're still alive before your will is kicked in. Because as we get to, your will only takes care of things upon your death. So we also want to make sure your kids are taken care of while you're alive. So we've got, ideally we've got a will in place to name a guardian conservator. We maybe even got a trust. We went through our documents or our assets to make sure they're all set up correctly. But let's talk about another situation we need to cover. What happens if you're in an accident, short-term situation? Kids are at the babysitters. The police have to come find them, and the babysitter's got nowhere to go with them. You don't have family around. You need to ideally have a plan in place for some short-term situation. Where is your kid literally going to go? Who lives close to you? Have a plan to notify those people that live close to you that they are listed as somebody next in line to take care of your kid, let them know a plan for that. And so again, to avoid the situation as we go down the line that the police have your, I'm just like, I'd get sick thinking about Stella just sitting with the police while they find somebody to take care of her. If, let's say me and her dad are in an accident or something, or even Child Protective Services. Keep going, Emily. And so ideally, you'd have something in writing that documents these people, have a card in your wallet. So if you're found, they know who to contact, and have some instructions for those caregivers in an emergency situation. Next slide, please. The full plan to safeguard your kids is going to have that guardian conservator in your will. Just to summarize this, have a plan for a temporary situation, an emergency person that can take over the child and any money to take care of them, an authorization so that if their grandparents are taking care of them during a vacation, they can take them to the doctor and get them taken care of, and some instructions for those people. And that's kind of the ideal plan to take care of your kids if a disaster happened. And so let's move on from this really uncomfortable topic, but important, to get into maybe the next step of it, for the estate planning for the adults to take care of everything.
So the good, the bad, and the ugly of estate planning. There are, in order to put in to have a legal effect to what Jenny was just talking about, with knowing, what would happen with your child if you were in an accident, or knowing what would happen to your resources or your child's inheritance. We can make a plan for that. Now, again, as Jenny mentioned, this judge is going to show up several times. The do nothing plan, and that's kind of the first thing that we talk about, because the state of Kansas, and like all states, has a plan for you in place, and if you don't do anything, then a judge is going to be the one that implements that plan. And so, like Jenny was saying, if at age 18 your children are just going to get everything. I remember what I was like when I was 18, and that may not have been the best choice for my situation. And I've talked with children who have received resources at 18 and older, and having some protections. The ones that I have talked to have always said that it was beneficial to have those protections, and made them feel better about how to work through those resources. The nice thing, the first thing we talk about is a will. It tells who receives your resources when you die, sets out who's in charge of everything, but at the same time, a judge oversees and looks at everything. Having said that, if you have children under the age of 18, a will is the only way to tell a court and to have your voice heard about who's going to care for those children, who's going to care for those resources that you leave them if something would happen to you. It only controls if you don't have a beneficiary designation on a resource at the time, and it's got to go through probate. So again, a judge has to look over things. So one way to think about a will is it is a admission ticket to probate. Probate takes a long time. It can take a year or longer. Hopefully during that in-between time, things are happening and resources are being used to care for your family, but that's not always automatic for sure. So again, probate's court proceeding takes about 6 to 18 months. It can be expensive. There are accountings that have to be filed. Every penny has to be accounted for, and the judge gets to choose gets to ultimately say whether or not those expenditures were appropriate. The other piece of that is it makes everything public. So not only does the judge have access to all this information, but everybody else does. That means other family members. That means your children, when they turn age 18, is going to get to see everything. And you may not want people in your family to see that information. And then if you've got property in Kansas or outside Kansas, there may be multiple probates in every single state, because property in Kansas can't be ruled on by a Colorado court. And if you have Colorado property or Nebraska property, something that happens in Kansas doesn't necessarily transfer to those other states without having a second court involved. In a typical will, a lot of wills we see before we sit down and work with folks is that it leaves everything to a spouse. And if your spouse is deceased, to your children, and they get that at 18, and then have a guardianship and conservatorship nomination. That's kind of what we call I love you wills, or what we would consider a simple will, and yet that has some interesting information. So if, especially in blended family situations, if someone dies and leaves resources to their spouse may get remarried and leave things to other individuals, so that at the end of the day, children aren't able to or don't receive the resources that their parents worked hard to create. So that kind of brings us to what a trust is. A trust really has it's really an instruction booklet or a manual, or basically a description of how what you want to have happen to your resources upon your death. It's got 3 people, usually, sometimes there's a 4th, but the main person is the grantor, the trust maker. So that's probably going to be you, or I have a trust for my family and for my children, so me and my wife are the grantors of those trusts. There's a trustee, so that's the person responsible for carrying out all of the terms of that trust. And then there is a beneficiary, so that's who's going to receive resources from the trust. And you can see that the trust is kind of like a wagon. We talk about it as a wagon or a car, and we need to make things payable on death to that trust, or put things into that trust to make it effective. It's very common in estate planning too. It's very flexible. You can be your own trustee. So I'm my own trustee. I'm my own grantor of my trust. I'm the beneficiary of my trust along with my wife. If something would happen to me and my wife, my children are the beneficiaries of that trust. The other nice thing is once you get it set up, it's very easy to change. So we can go in and change who receives what and how much and when. And you can do that anytime you want. You can get rid of it anytime you want. But the biggest thing is that it avoids probate. So anything that's in a trust doesn't have to go through the court system, doesn't have to go through probate. You don't have to have a judge look over and approve what's happening with that trust. Sometimes there are some shortfalls if you have a trust. So if you do already have a trust, I'd go look. It doesn't have incapacity provisions. So I know if something happens to me and I can't make decisions for myself, my wife will do that, and then followed by actually my brother, or my parents. It doesn't have any. There are sometimes some trusts we see that they don't have protections for you, or for your spouse, or for your children. So there are protections that we've built into our trust, specifically my trust, to protect things for my wife, to protect things for my children, so that if something would happen to me, they can still have an education. They can still set their goals and achieve those. Some things, some other items is that if we are looking at long-term care, have blended families or remarriages, we can plan for those types of things as well. So one thing that we do counsel against is making your children the beneficiaries of your resources. So my trust is the beneficiary of a lot of my resources, along with my wife. And If we just put the kids' names on there, then again, that opens up probate, that opens up a guardianship and conservatorship, and that opens up the ability for them to have those resources at age 18. So we can, make your estate plan kind of like a treasure chest. You can protect our children from accidental disinheritance, from their own immaturity, or if they would ever get sued or go bankrupt. So that's kind of what we need to talk about when we're thinking about what happens upon your death or disability. But how do we, even now start working to protect ourselves from things that might happen, Jenny?
And when you get on an airplane, the instructions as far as putting on your own oxygen mask first before taking care of somebody else really applies here, because that's what we want to stress is what do you need to get in place for yourself, so that you can then take care of others, or they can take care of you. So we're going to go through that. Here's the judge again. I really like it. If you don't have a plan, we can probably guess by now, this judge is going to decide. If you don't have somebody named that you want to be guardian for yourself, we talked about guardians for your kids, but this applies to anyone, it applies to you. Have somebody named as guardian over your person and over your resources, or you're going to see this judge again. You deal with the court, it's time consuming, there's legal fees. You may not get who you want, and then there's some accounting on top of that. It's kind of like probate. We just don't want to go there, and there's ways to avoid it. In addition, if you don't have good healthcare planning documents, your family might get the silent treatment if they try to ask about how you're doing, and don't have the proper HIPAA releases. So that's really important to get those people named.
Can you give us an example of how that works, Jenny?
So we have, and tell me if I'm on the right track for your question, we have our own HIPAA authorization that we have families. It may not be the person that you want making decisions for you, but there may be several people that you want just to be able to ask questions about your care or how you're doing, just to receive information about that. You need to have specific authority for that, especially if you're not like the immediate spouse or immediate kid. If you're further down the line, you're probably not going to get information.
And so what happens if you don't have, those authorizations? How would someone end up getting the silent treatment, I guess?
As far as they just simply don't get information?
Yeah, pretty much.
Okay. And then I thought you were going to say, then we just go back to the judge. But we don't want to see him again.
There you go.
And so, Adam, can you give an example of maybe how this plays out in real life? In addition to having the documents, you also want your family to know just what you want.
Yeah, and so my grandfather, one of the ways that I started, focusing on these issues, he had Parkinson's, and we went through all of this planning with him when he got that diagnosis, so that my grandmother, wouldn't have to struggle with making decisions. She, didn't have to fight with anybody. We all knew what folks wanted, and we were able to put all of those things into place. And there was a lot going on at that time, and this was one thing we didn't have to worry about. And that's where it's good to have these conversations now, to get this planning in place now. So if we do end up in a crisis, we don't have to have those conversations then. So is a healthcare power of attorney good enough?
And it seems that this is just kind of how it works with our work. It's like you get a basic in place, and then you take another step to make it better. So having a healthcare power of attorney is great. You absolutely need one, but it's not quite enough, because you're giving someone authority to make decisions for you, sort of like they're God for you, but you haven't them given any guidance about what your wishes are. And so that's the next step to really complete it. is to have a living will that addresses your end-of-life decisions, in addition to having those conversations. And conversations are really important, but you really need to have it in writing so that a doctor or hospital can have that documentation when you're going to make a tough decision. And then again, that HIPAA authorization is another thing on top of the healthcare document, or you want to make sure your healthcare power of attorney has that language in it, so that whoever you want, if you've got kids that you may not want to make the decision for you, you probably still want them to be able to check up on you and get information. He's back. And so if you don't have a power of attorney, as far as somebody to take over both your healthcare and your finances, you're going to court to get that guardian and conservatorship, which again is dealing with the person and the finances. Again, on the guardianship and conservatorship, this goes for, and we repeat it because it deals with both your person, yourself, dealing with healthcare decisions and where you live and all that, and also your finances are kind of two separate things. They generally happen all at once, but the same headaches apply to both pieces of it, the guardianship and conservatorship. So to have your healthcare covered, we talked about a healthcare power of attorney and the additional documents that go hand in hand with that. On your finances, we need a durable power of attorney. You might hear it referred to as a financial power of attorney. So this is where you put into writing the person that can manage your finances, pay your bills, make changes to accounts if they need to, talk to insurance companies, everything that has to do with your assets. And so you can choose, it might be your spouse, it might be your kids, it might be a combination of those, but basically the person that you trust to take care of those things. A lot of people assume that if they're married, their spouse could just take care of things. And the law just doesn't assume that you're like your spouse, which is a good thing as a whole, but it just causes problems if people assume that their spouse could just take care of whatever needs to be taken care of. Now, that might be true for a bank account if it's joint, because the joint owner can always still have access to that account, which also plays into maybe that's why you don't want to have your kid as a joint owner, because they have full access, and that's a whole other topic. But a joint owner can have access to that account in an emergency. So you may be covered there. But a lot of times people forget about retirement accounts or stocks or insurance or annuities that maybe there's only one person that's the owner of. The spouse does not automatically have access to that. And frankly, those companies are not going to talk to that person, even if they're a spouse, without a power of attorney that has specific language in there. So you've got to remember that. Even if you have a power of attorney, they may be a little powerless, because having the document in place is not enough. It really comes down to what is in that document. And so if it's a springing power of attorney where someone can't act because of incapacity, there might be an extra hoop to jump through with a doctor's letter for the power of attorney to have authority. You want it to make sure that it has provisions for retirement plans and long-term care planning and HIPAA authorization and asset protection, and that you want to stay home if you protect your home if you need long-term care. In addition, we have language about your intent that you want to stay home. And then on top of that, in Kansas, I think, Adam, we said there's about 14 powers that, unless you have them specifically in there, they're excluded. And a big example of that is the homestead provision. The Kansas Constitution says that there are some specific language you have to have in your power of attorney. And I really can't stress this piece of enough as far as how important this is because if you are in we've kind of talked about these worst case scenarios that first responders could land in, and you need some planning done to protect your house, you got to have that power in your power of attorney for anybody to do anything with it. Or if you need to change some beneficiaries on your accounts, you got to have that power in there, or you're stuck. So what I'm talking about is a power of attorney that's powerful, that has that language about retirement accounts, that has that language about long-term care planning and Medicaid planning and division of assets and the homestead. And really it's probably a little more of an investment to have a good document, but this is a real life example, but that having the right language in there can save tens of thousands of dollars in the end because of the planning that can be done with the powerful document.
So Jenny, can you, I mean, we've seen a lot of these different powers of attorney over the years. Um, what happens when we want to run across one that just doesn't have this stuff? Like, I mean, do you have an example?
Yeah, I've got examples of, gifting is one that, well, this is getting into long-term care planning, but there's some strategies we can do that involve gifting some assets. And I see powers of attorney that limit gifting to the annual exclusion, which really doesn't, it limits what we can do. We may have to change a plan to gift to multiple people to spread it out, or quite frankly, I mean, we do everything we can to think of a way around this if we know it's good planning. Sometimes we're just stuck. Sometimes we can't transfer the home because it's just not there and nobody has capacity anymore. So that's kind of the worst case scenario is we have to tell a family that, look, we've given you these options and this great stuff we can do, but we're stuck because we don't have the legal authority to do it.
Speaking of gifting and the estate tax limits, we get to talk about estate tax. The good news is there is no Kansas estate tax at this point. The other, I don't know if this is good news, but the current federal estate tax exemption is 11.4, and now it's actually 11.58 million dollars per person. So a married couple would have a $22.2 million exemption, give or take a few $100,000. But that expires December 31st, 2025. And although Congress has not ever let that estate tax exemption decrease, depending on what happens in this current election and then the next election, this may be the time when we actually see those limits come down. So at this point, a lot of folks were starting to think about that. And when we have resources that are, extensive life insurance, that's something that we need to certainly be talking about. That's the other piece, is that, as I mentioned, these federal estate tax rules are always subject to change. So if your resources are approaching $4 to $5 million, then we need to start sitting down and talking about that. Or if you play the lottery on a regular basis, because we have seen attorneys in estate plans that haven't had any tax planning in them. Somebody wins the lottery and then deceases, and then there's a very large check that gets written to the IRS that didn't need to be that way. So even if you don't have those resources, it's still not a bad idea to sit down and have a conversation about those taxes. The other big focus is income tax. So that can be as important in tax planning. So if you're passing real estate on to the next generation, then we want to make sure that that generation isn't unnecessarily taxed by taking advantage of step-up and basis rules. The other piece of that is there is a brand new law when it comes to IRAs and some retirement planning called the Secure Act. It went into effect on January 1st, and it significantly changes. So it used to be that we were able to stretch IRAs throughout beneficiaries' lifetimes, and now we have limited that to only a 10-year period, so that accelerates those taxes that are paid on retirement accounts. And the federal government is thinking that it's going to get $15.7 billion in the next 10 years from that little acceleration. And we can work with minors, we can work with charities, we can work with some very special beneficiaries. Your spouse is one of those beneficiaries we can work with to reduce the amount of income tax that's paid on those inherited IRAs. And then a lot of what we see is people that are kind of in the middle right now, what we've called the sandwich generation. And so, Jenny, what are some of the struggles that you see those in the sandwich generation starting to suffer?
So this is the generation that is both caring for kids and caring for their parents. And we're not there yet, Adam, but we're going to get there. And so something to think about is just compare it to home insurance. If you own a home, you probably have homeowners insurance. You would rather let the insurance company take the financial risk to rebuild than take that risk yourself. And some kind of, scary statistics, honestly, when I was looking at this, it's like we know this, but seeing it again was like, oh gosh. So just think about this. If you're in this sandwich generation, you're not really looking at long-term care. You're taking care of your parents. But it's something to keep in mind, both for your parents and for yourself, because there's going to be different planning options, at what stage you're in, that depending on what you look at, the U.S. government said that 70% of individuals 65 or over will require long-term care. The same study said 20% will need care of 5 years or longer. That's a lot of money, and we'll get to that. And Department of Health and Human Services says 40% of those 65 and up will enter the nursing home at some point. Wall Street Journal says that 80% of American couples over 65 will have one spouse that needs nursing home care. That's almost all of them. And so you got to keep that in mind, and not, nobody wants to go in the nursing home, but the consequences are so big and it's so expensive, which we'll get to. But some additional statistics that aren't any more comforting is that by 2030, the number of people with Alzheimer's is expected to double. Dementia can range from 48 years after diagnosis, can go on as long as 20 years. The average is 8 years of care. And we see that with care at home that transitions into nursing home care. It's a long journey. And as far as your family is concerned, a statistic from a long-term care planning guide, 26% of family members wind up using their own retirement assets to care for their parents, because keeping somebody at home is expensive, or finding care. Getting to the nursing home and getting Medicaid is sometimes the easy option, but staying out of there can get expensive. And if you care about someone, you might end up using your own money to do that.
Right, and I think I heard that 1 in 3 people ends up with Alzheimer's at this point. And what that means is that the other 2 people are probably caring for somebody who have Alzheimer's. And so it's not just that you may get Alzheimer's. It's also, what's the impact upon your spouse or your kids if that happens. So what do the costs of care look like, Jenny?
Yeah, and this is highly dependent on your area. Western, I know I don't want to say this all, but in Hayes, small town Kansas is generally a little less than, like, say, you go to Wichita. But it's not too far off. And these numbers, let's start with home care, could be $16 to $30 an hour. And man, when you get to 24/7 care, if somebody wants to stay at home 24/7, it usually comes down to money, because it is expensive. If you've got the money, you can probably stay home. But if you don't, it's going to be very difficult, and you're going to be relying on your family. And so you may need to move to an independent or assisted living. Then you're jumping up to $3,500 a month. For a really nice assisted living community, you might get up to $8,000, especially if you've got memory care. And then if you get to the traditional nursing home, around here, it's going to be $6,000 to $7,000. You get into Wichita in those areas, it's probably going to be $9,000 or more, depending on if you're in a private room or not. And so that month by month, that really adds up. And so really, long-term care costs are potentially the biggest threat to your retirement security, because it's so expensive. And a lot of people think that planning for long-term care is expensive, but the reality is that paying for it is by far more expensive. And if you feel like you're in the situation where you're either thinking about yourself or thinking about a parent, we've got another seminar coming up that's planning for the second half of life. It's really going to get into that in a lot more detail. And we've got some 8 steps to to protect you and your family and your assets. And so that'd be a great event to jump on, and we've got the information on here. So Adam, we've talked about a lot of the basics, but what's another extra step that if we, to really put a roof on the house and protect it, if that's the right thing to do?
So if we do have farm ground or businesses that we want to protect, we talked about a revocable living trust earlier, and those are great for caring for you, passing your resources on to the next generation, um, and also setting it up so that your kids can benefit from your resources that you've worked hard for. But it doesn't necessarily protect things from long-term care costs. It doesn't protect it from nursing home or creditors or Medicaid or state recovery or any of those types of things. And so one of the things that we do, one of the more advanced planning, is putting together an asset protection trust. An asset protection trust is a trust that's specifically designed that we work with to protect those things that we find most important. So that would be a business, a family farm, something that's been in your generations, something that we call the family jewels sometimes. So you can kind of think about this as a piggy bank. So a revocable living trust is kind of like mason jars that I give my kids their allowance out of every single week. You can put things in, take it out whenever you want to. But an asset protection trust or a Medicaid asset protection trust provides income to you, but it protects those resources through your lifetime. As long as we can wait 5 years before applying for Medicaid, then those resources are protected. So again, who might this apply to? Someone if you have rental properties, if you have farm ground, you have a vacation property, a vacation trust that's been in your family for a long time. In fact, we had a family that had a cabin in Colorado that they really enjoyed going to. And we proposed a asset protection to the trust to them about 7 years ago, and they chose not to do that. And so then last year they came in and said, well, we've got some issues, and this person's going into the nursing home, and we were sad to say that cabin was open, and we were going to have to sell it in order to pay for long-term care. Where if we had done that asset protection trust about 7 years ago, we would have been through the 5-year waiting period. That cabin would have been protected. And so that's just one strategy. But that kind of leads me to kind of the biggest enemy. We've talked about taxes, we've talked about long-term care insurance, we've talked about what would happen if you were in an accident or ran into a crisis situation and were injured. But really, kind of one of the biggest things that a lot of that folks struggle with is procrastination. And so I'm a big Benjamin Franklin fan, and one of my favorite quotations from him is, by failing to prepare, you are preparing to fail. Kind of like that family who we had talked to, we had put a plan together, and they chose not to go for it. They chose to not have that. And so when they then got into a crisis, instead of having those protections available, they weren't. And that's why a plan isn't just a document, okay? Jenny and I have seen the LegalZoom trusts and the wills and all of that stuff, but it's really about talking about you and your dreams and your goals, talking about your family situation, and saying, okay, if one of these events happens, how are we going to respond to that? Kind of like running into a burning building. That if a building is burning, or there's a situation that requires law enforcement, you know what the plan is, and it's written down someplace, and you've gone through training on it. And that's what we've done, is that we have sat down, we have looked at these things, we've had these conversations with lots of people. And so we put a plan together, and then we put together the legal documents that support that plan to make that come true. So while this may not, be necessarily as fun as planning a family vacation or planning for Christmas, or, and it may um, hopefully just kind of sit there and wait for something to happen. That's kind of the same thing that you do every single day. You prepare, you train for that crisis situation, and that's what we do. We sit and we train for that. Jenny, before we go on to what's next, do you have any thoughts about how to get over that hump of procrastination that we encounter every now and then?
I was just thinking that when you were talking about, your family and what they could have done, a lot of times, oh, and seriously, a lot of times I hear, gosh, I wish we would have done this 5 years ago. Um, and so I think for me, it's just like, what's the smallest step you can take to not procrastinate it? I'm a procrastinator. But to me, it's like, that's why we're here is the smallest step is to just, and Emily will, this is going to be Emily's piece, is just make a phone call and then have that step to find out, what your options are to just get the ball rolling, and have somebody along with you to push you to get that done, because it is hard to make that leap, but once you do it and it's done, it's worth it, kind of like anything you procrastinate. So just don't, and for me, it's just don't be the person that says, man, I should have done this 5 years ago, because the consequences are pretty big. And like you said, back to Benjamin Franklin, if you don't plan, then you're probably planning to fail in the end.
So what is our if someone did call in, what is that going to look like? What's going to happen?
Great question. So the first part, and this is kind of what I was getting at. The first part is really easy. You call and you'll probably talk to Tracy, and she's really nice, and she's just going to walk through your general situation, your assets, your family, what's going on, and she's going to make the call on if it's something we can help with, if you're a good fit, before you actually schedule a meeting. And then we're going to have a meeting. And in this age, it might be a Zoom call, it might be an in-person meeting. We're really flexible on that. And you or me or Randy, one of the attorneys, is going to have that meeting to go over the plan and have a strategy. And then after the meeting, we're going to do our work and prepare the documents and have the signing. Then, like we talked about, it's one thing to have your documents in place, to have your plan and meet your goals, but then you got to make sure on the back end all your assets are set up correctly. And that's what we're going to do, is make sure every single thing is set up correctly, so the plan you put in place in the documents is going to work. And then we've got another program where we have an ongoing relationship with our clients, because things change and kids get older and assets change, so that we can really keep track of you and can check in with you, kind of that procrastination piece. If you have somebody checking in with you to make sure you're keeping things updated, that's really huge. And so we love to continue the relationship after the signing.
And so if you want to start getting your ducks in a row, or if you know that you want to have a second look at your ducks to make sure they are in a row, Emily's going to be putting a link to a Survey Monkey in the chat box, and if you just click on that, that'll take you to a really easy survey. When you do that survey, let us know if this was helpful. Let us know if Tracy can give you a call so that we can start on getting ready to sit down and talk about your personal situation. And then that consultation is free. And at that point, we'll sit down, we'll put that plan together. Other upcoming events we've got are on our website, elderlawkansas.com. What you really need to know about the second half of life, we're going to present with Adams, Brown, Barron, and Ball certified accountants on September 21st. And then we're going to have 7 things savvy young parents need to know about estate planning on October 13th. Since at that point we'll all have gone back to school, whether or not we'll all be in school is another question, but we'll all be doing learning at some point. So I'm looking at the chat box to see if there are any questions. I'm not seeing any. Emily, are you there? Do you see any questions? Have I completely stolen your thunder at this point?
Nope, we're all good. It doesn't look like we do have any questions at the moment, so I think we'll go ahead and wrap up. Thank you everyone for your participation today. We really hope the information that we provided you was helpful. Please feel free to contact us at 785-625-8040, and we can provide any additional resources, books, brochures, contact information, etc. if you have any further questions, and we'll be very happy to contact you at either of our offices in Wichita and Hayes. So once again, we just want to really let you know that we appreciate your attendance and want to thank you for everything that you do to protect our communities and families. So with that, have a great rest of your afternoon, and please let us know if there's anything we can do to help you. Thanks.